Welcome back to the program. So I know a lot of people are upset. I know that they probably have a lot of questions about some of these decisions at the Supreme Court, the birthright citizenship decision, of course, the mail-in ballots decision. So I'm going to try to go through some of that with you today, as well as some other topics. But instead of me ranting and raving about everything, I figured I'd let Stephen Miller cut in a little bit and let him do it.
A citizen, that baby can sit on a jury when he turns 18 and sit in judgment of you and sit in judgment of me and sit in judgment of our loved ones, can decide who our mayors are, our governors are, our presidents are. Citizenship means nothing if it is open to everyone. The idea that you can have a cruise ship filled with foreigners and they just dock at a port for an hour and someone has a baby, Jesse, the baby's an American citizen. They can vote in every election for the rest of their lives. They can be living in a foreign country and cashing welfare checks from American citizens. Look, I know that some of the justices who worked on this, they think that they're so intelligent. There is no possible reading of the 14th Amendment that applies to foreigners with foreign loyalties, foreign citizenship, foreign obligations, foreign everything. And here's another point. Here's a pretty good clue.
So anyway, that was obviously Stephen Miller, okay, going off on it. Now, what I want to talk about next is what is next, okay? So Senator Rand Paul from Kentucky, has introduced legislation to end birthright citizenship. This is a bill that we need to get behind right away. Remember, what the Supreme Court failed to do, Congress can do, okay? And that can't be undone once it becomes law through Congress. So if we can push the Senate to actually take up his bill, get it out of committee and get a vote on it, or get rid of the filibuster to get it passed, that's what we need to try to do. So there are ways and mechanisms to get some of these failed decisions to actually become good decisions. Now, there was also some other good decisions out there, and we're going to go through some of that stuff as well. But what I want to do right now is I want to read you, okay? This is from 1866, May 30th, 1866. This is the U.S. Senator, what is his name? Jacob Howard, the person who wrote and introduced the 14th Amendment, okay? So this is pretty important stuff. So here is what it says. The motion was agreed to and the Senate, as in committee to the whole, resumed the consideration of the joint resolution H.R. number 127, proposing an amendment to the U.S. Constitution of these United States. To the President pro tempore, the question is on the amendment proposed by the Senator from Michigan, Mr. Howard. The First Amendment is to Section 1, declaring that all persons born in the United States are subject to the jurisdiction thereof. Again, there is that famous phrase. Subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. Now, if that was all the 14th Amendment said, then this decision by the U.S. Supreme Court would be correct. But it's not. And the left has bastardized this 14th Amendment from 1866 by ignoring all the rest of the text like they always do, right? We just want to go with what, we feel is important. Don't worry about that other stuff that says that we can't do what we're going to do, but we want to be able to do what we want to do, right? So listen to the rest of this, okay? I do not propose to say anything on this subject except that the question of citizenship has been fully discussed in this body as to not need any further elucidation. In my opinion, this amendment, which I have offered, is simply declaratory of what I regard as the law of the land already, that every person born within the limits, again, within the limits of the United States and subject to the jurisdiction thereof is by virtue of nature, law, and national law a citizen of the United States. Fine, okay. But what about this part? The most important part that the left and everybody else, including the Supreme Court and Amy Coney Barrett and the rest of these scumbags left out, this will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of these United States, but will include every other class of persons. It settles the great question of citizenship and removes all doubt as to what persons and who are not citizens of these United States. This has long been a great consideration in the jurisprudence and legislation of this country. This will not, of course, include persons born in the United States who are foreigners or aliens. That's the part they have left out. That is also the part that the scumbag five on the Supreme Court refused to even acknowledge. So in other words, they made not only a horrible decision, but they made a decision that is unconstitutional in the fact that they adjudicated it incorrectly. And therefore, they put a decision up that is wrong. It is 100% wrong. So the only way that you're going to fix that is through Congress. And it looks like Rand Paul has taken the ball right away and is introducing legislation. So we'll see what happens on that. If I was you, I would go to contact my politicians, and I would reach out to your senator, especially a Republican senator, and tell them to get on board with the Birthright citizenship law that Senator Rand Paul has just issued. Okay? Now, let's talk about some other things. Okay? Let's talk about. Well, here. Let's get to this. Let's get to this first, and then we'll get to the other part. So the case with the mail-in ballots, again, a horrible, horrible decision. But it might not, in the end with just this. Let me explain. The Supreme Court handed Trump an election case defeat, clearly. But is a bigger win just around the corner coming for him? That's the title to this. The Supreme Court's ruling letting more than a dozen states keep their post-election grace periods for mail-in ballots is a defeat for President Donald Trump and Republicans ahead of these midterms. But the GOP can still capture significant victories in major election-related cases coming further down the pipeline. On Monday, 2 Republican appointees joined the 3 liberal justices in rejecting GOP claims that federal law did not allow states to count postmarked mail ballots that arrive at election offices after Election Day. The ruling upheld Mississippi's 5-day mail ballot grace period after the Fifth Circuit Court of Appeals had it struck down. The case, of course, was RNC versus Mi Familia Vota. Yeah, obviously illegal aliens versus the RNC. Should have just said that. Could also give states the green light to conduct mass voter purges of suspected non-citizens in the days and weeks before an election. The case won't likely be settled by these midterms, but it does stand to be resolved ahead and before the 2028 general election. It fits into President Trump's agenda of pushing for more aggressive action to clamp down on non-voting, which studies have shown to be rare. This is CNN, so obviously it's not rare. It's extremely, extremely happening all the time in every single state. Both cases come down to interpreting laws passed by Congress. And then it says, a White House advisor, Justin Levitt, a Loyola Law School professor who served as a White House advisor on voting during the auto pen administration on Monday. The court said that the Congress did not intend to restrict ballot receipt deadlines for mail ballots when it standardized the federal election day in November. There's an Arizona case coming out of Arizona that could actually upend what the Supreme Court just failed to do, basically, okay? There's an Arizona case, and this is Arizona against the National Voter Registration Act. And what they are saying in Arizona is that we should be able to not have to count, of course, illegal aliens and non-citizens, and they should not be able to vote. Trump and Republicans may have lost on the mail ballot deadlines this spring, but the Supreme Court obviously gutted the remaining Voting Rights Act, made it fair, got rid of gerrymandering and all of that. Now, it says, let me see here, where is it? Here it is. So the Arizona, here it is. Arizona tried to conduct mass purges in the days and weeks before the election. Lower courts have blocked these purges because of the National Voting Rights Act, so-called quiet period. But the Supreme Court has previously signaled a much different view, having issued an emergency order just days before the 2024 election to let other states, including Virginia, restart a mass purge aimed at non-citizens. So in the meantime, the Supreme Court's ultimate ruling on the Arizona law could determine that ability of states to implement their own statutes that would then achieve the same exact goals on voter proof of citizenship that something like the SAVE Act would do as well. So I bring that up because I want people to know there are other lawsuits coming at the Supreme Court. This court has been a mixed bag. They've done some good things, VR2, right? Got rid of that. But then they do these horrible things. Birthright, citizenship, and the mail-in ballots. I thought, honestly, we were going to get 2 out of 3. I said publicly we were going to get the mail-in ballots. I was wrong. And I said we were not going to get the birthright citizenship. I was correct. And I said we would probably also get the no trans, men and women's sports. And I was correct on that. So I was a little off, but hey, that's, just the way it goes. But I want to point out something else. Now, I alluded to this briefly in the Jeff Carrere interview, okay? And in the Jeff Carrere interview, I talked about how we have basically just gutted the deep state and the ability to fight back when they're fired. And again, that was something that I put in Preserving Liberty. So this is an interesting article. It says John Roberts, not our favorite by any stretch, has fought for 43 years to overturn the Humphreys executor clause. For more than 40 years since his service as a young Reagan administration lawyer, Chief Justice John Roberts had pressed for an exceptionally powerful U.S. president, one who could fire heads of independent agencies at any time. In one memo in the White House Council in 1983, Roberts asserted, "The time is ripe to reconsider the constitutional anomaly of independent agencies." When he was appointed Chief Justice in 2005, he began laying the groundwork to reverse Supreme Court precedent that permitted Congress to limit the president's firing power. Without such power, Roberts wrote in 2010 case, the president could not be held fully accountable for discharging his own responsibilities. The buck would stop someplace else. Roberts' effort climaxed on Monday, interesting word, as he led a majority to reverse a 1935 case. 93 years, of legal precedent was reversed. Humphreys Executor versus United States that allowed Congress to restrict the president's authority to fire agency heads to ensure their independence. From his seat at the center of the elevated bench, the Chief Justice observed that the court had been steadily backing away from this 1935 precedent, which he insisted conflicted with constitutional history and structure. If anything more is left of Humphreys, we, quote, will overrule it, he said. Controversy over the regulatory sphere can seem dry compared to Supreme Court battles centered around the Second Amendment, abortion, reproductive rights, religion, immigration, etc. But he has worked on U.S. independent agencies to cut a swath across American life, for better or worse, imposing requirements on businesses and individuals in areas of public health and safety and consumer protection with the goal of enhancing the common good. Our Constitution creates 3 branches, but only one president, Roberts wrote, expanding on his position in his 36-page opinion. that president is not all powerful, not by any means, but he is not impotent either. He and he alone is vested with the executive power of the United States. Robert's sweeping approach to presidential power has manifested itself in multiple cases over the years, perhaps most notably in 2024 when the Chief Justice and fellow conservatives gave President Trump a substantial immunity win from criminal prosecution, pointing to the president's conclusive and preclusive authority. His long-game effort to curtail independent agencies such as the Federal Trade Commission at the center of the ruling on Monday is not unlike his successive moves, curtailing the reach of the 1965 Voting Rights Act that drive culminated, of course, a few weeks ago. So this is what's interesting about this decision. This decision, and there's more to it, and it's minutia, and I don't really want to get into it, but this decision now gives President Trump a huge, huge amount of power to fire the heads and the workers of just about any agency in Washington. Now remember, for 93 years, whoever the president was, they had limits. It's weird that they left, Lisa Cook and the Federal Reserve. But in some respects, I kind of understand that, because God forbid we had some weirdo that has no mathematical sense whatsoever, and he's a commie socialist, and he just wants to take everyone's money away, and he goes, the Federal Reserve guy is a commie, and he goes, I want 100%, rates on mortgages, on income, on everything, right? Well, hey, that's a problem. That would be a major, major problem. So I understand why they did that, because you're not going to have someone with the ability to do that, basically. Okay, you can't have like a president come in the future and be like, we're going to do 100% income on everyone who's a registered Republican, because that's just the way it's going to be. The Federal Reserve, they're not going to allow that to happen. So I do understand from that standpoint why they made an exception for the Federal Reserve. But quite frankly, the Federal Reserve shouldn't even exist. We should be back on the gold standard of 1913, but that's a story for another day. So I wanted to kind of point out in Preserving Liberty, on page 50, in chapter, what is this? Dismantling D.C. I'm just going to read this paragraph. I said, ending the Administrative State Act. This is something that I created. I thought about it and created it. If we are going to get serious about permanently draining the swamp, then we will also need to permanently fill in that swamp as well. I propose that as soon as the next president-elect wins the next general election, every member of the previous administration is put on notice. Under the proposed Ending the Administrative State Act, once the transition team is established, every former official must reapply for their jobs within 30 to 60 days. If they fail to reapply within that time frame, then they will be automatically terminated. If they do decide to reapply for their jobs or another job inside the new administration, the transition team would then have 60 days to decide whether or not to retain them or terminate them. This would give the new administration the autonomy and control in deciding not just who will be in their cabinet, but also who will not be in their administration. It will continue to keep the President of the United States from being undermined and spied on and have subversives drastically infiltrating the administration, cutting down on leaks, etc. This will allow the new president to truly call it their own administration. Now, that was something, that I created and talked about. Well, what the Supreme Court has just done is basically created the Administrative State Act, which was from my book. Now, I'm not saying that they got it from that, but this decision mirrors what I said, basically. The only difference is in what I said is I went a step further, and I said that at the turn of a new administration, everybody that worked in the previous administration is immediately on notice in limbo that they don't have a job. That's how you really drain the swamp. So if they would have done something like that, and again, I don't believe there's been a lawsuit that has come forward to the court. Remember, the court can't make up cases themselves. They have to hear cases, right? So unless someone files a lawsuit saying that all presidents moving forward should not have to have prior administrations, officials, and deep state entrenched SES, senior executive services individuals, serving in their next administration, well, then, hey, maybe they would make a decision on that. But in a more toned down way, this decision allows the president the ability to fire a hell of a lot more people. So I would assume in the next months to come that you're going to hear in the news that President Trump is firing this person, he's firing that person, or firing this person, because President Trump is thrilled with this decision. So I wanted to point that out because that is another way that we can help drain this proverbial swamp. Now, the other thing that I was going to say real quick in this segment is we need to understand that there are multiple more cases that are coming, not in this term. This term is now over, so they don't come back, I guess, until October. But in October, there's going to be more decisions, lots of more decisions, including, again, possibly one of the first decisions they take on would be the Arizona case. And if they rule the correct way on that and kick it back to the states, then it'll basically be where states will then be allowed to go through their own voter rolls, making sure that all the people are eligible to vote and are legal citizens. So it'll almost create mini save acts all over the place. And at least for purging of voter rolls and making sure that illegals are not voting in our elections. So keep your chin up, keep fighting, and there's a lot more to go. Those are my thoughts. What are yours? Put them down in the comments below. We'll see you in the next one.